I mean, imagine you buy $1 million token representing this massive ultra-luxury penthouse in Manhattan. The smart contract is totally flawless. The blockchain it runs on is, virtually unhackable. You've got the token sitting right there in your digital wallet. But then tomorrow you wake up to find your token is just legally worthless.
Yeah, and not because of a hack or a market crash.
Right, not a hack. Simply because somebody, somewhere, forgot to file a specific piece of paper in Delaware.
And that right there is the ultimate blind spot for anyone looking at tokenized real-world assets today. I mean, the market gets so fixated on the cryptographic security that it just completely ignores the legal reality holding the entire thing together.
Welcome to today's deep dive. We are looking at some source material today that is a highly detailed, frankly, eye-opening institutional script that breaks down the inner workings of tokenized markets.
Right.
It really focuses on taking things like real estate or treasury bills or private credit and putting them on a blockchain.
Right. Moving traditional finance on-chain.
Exactly. And our mission today is to map out what this source calls the invisible legal engine room.
Mm-hmm.
So the paperwork, the custody setups, the compliance frameworks that actually dictate whether your token represents a real-world asset or just a string of meaningless characters.
Because look, without that underlying framework, tokenization is effectively fictional. The core thesis from our source material is simple, but it's profound. Tokenization isn't merely technology, it is law. I mean, a smart contract cannot legally compel a property manager to just hand over the keys to a building.
No, of course not.
Only a legal framework can actually do that.
And for you listening, whether you are evaluating a new digital asset for your own portfolio, or maybe you're just insanely curious about how Wall Street is rewiring itself behind the scenes, understanding this legal skeleton is the ultimate shortcut. It's the lens you really need to spot a genuinely solid institutional-grade investment versus, well, just a digital facade. Okay, let's unpack this. Before we can even talk about how a token moves around the internet or who has custody of it, we have to establish what the token actually is.
Which brings us to the foundational wrapper.
Right. The source material starts with this foundational legal wrapper, the SPV, or Special Purpose Vehicle.
Right, so the concept of the SPV is essentially a legal vault. When an institution tokenizes, say, a commercial building or a massive portfolio of private credit loans, the physical asset itself obviously doesn't go on the blockchain.
You can't put a brick building inside a computer.
Exactly. Instead, the real-world asset is placed inside this legal vault, the SPV. The digital tokens that investors buy and sell represent legal shares of that specific vault, not direct ownership of the underlying asset itself.
So basically, I'm buying equity in the legal container that holds the asset, not a literal brick in the building.
Correct. You own a slice of the vault. And the source dives really deep into the legal mechanics of why this is absolutely mandatory. The primary function of an SPV is to create a state called bankruptcy remoteness.
Bankruptcy remoteness.
Yeah, it separates the risk of the asset from the company that initiated the tokenization. Let's say a major fintech company decides to tokenize a pool of car loans. They set up an SPV, they put the loans inside, and they issue the tokens. 6 months later, that fintech company goes completely bankrupt due to totally unrelated bad investment.
Oh, wow. Okay.
Because the loans are inside the SPV, they are legally ring-fenced. The fintech company's creditors cannot touch the assets inside that vault to pay off the fintech's debts.
Okay, I hear that, but I have to push back a little here. Buying a token without an SPV feels like buying a ticket to a concert that doesn't actually have a venue.
Yeah.
Like there's no legal reality holding it together. But what happens if things go wrong? You say the SPV ring fences the asset, but in the real world, creditors try to pierce the corporate veil all the time.
Oh, constantly.
If the token issuer is the one running the SPV, isn't that a massive conflict of interest that bankruptcy courts could just use to crack open the vault and liquidate those assets anyway? Who actually handles the defaults?
That is a crucial vulnerability. And honestly, it's exactly why a properly structured SPV isn't just a shell company on a piece of paper. To survive a challenge like piercing the corporate veil in a bankruptcy court, the SPV has to demonstrate true independence.
What does true independence look like in this context?
The source material notes that institutional-grade SPVs will have independent directors on our board. So people who have literally no affiliation with the parent company, they have their own bank accounts, their own operating agreements, and their own distinct corporate governance.
So it's totally sealed off.
Completely. If the parent company goes under, the independent directors ensure the SPV just keeps operating, collecting the yield from the car loans, and distributing it to the token holders. It is a completely independent organism.
So it's a bridge between the unyielding, automated nature of a blockchain and the incredibly messy, subjective reality of human legal disputes, which honestly points to a pretty massive variable here. If the SPV is the vault, then the jurisdiction where you incorporate that SPV is the material the vault is made of. And the source material spends a lot of time on this.
Yeah, because jurisdiction fundamentally dictates what the vault can and cannot do under pressure. I mean, the legal frameworks in different parts of the world offer vastly different mechanics for asset protection.
Right, not all vaults are created equal.
Exactly. The material highlights a few specific SPV structures that dominate this space, starting with Delaware LLCs. Delaware is basically the gold standard for straightforward single asset tokenization in the U.S.
And that's largely because of the Delaware Court of Chancery, right?
Yes.
That's the specialized corporate court system. So why is that specifically so valuable for a tokenized asset?
Predictability. The Court of Chancery has over a century of dense, highly developed case law regarding corporate governance and LLCs. If a dispute arises over a tokenized asset, say, a disagreement over how a default is being handled by the SPV, investors and their lawyers know exactly how a Delaware judge is likely to rule.
Because there's so much precedent.
Right. And that legal predictability drastically lowers the risk premium for institutional investors.
Okay, but what if an issuer is trying to tokenize 20 different private credit funds for an international investor base?
Yeah.
Putting all of that into one Delaware LLC sounds like an absolute nightmare if just one of those funds defaults.
Oh, it would be a complete disaster.
Yeah.
Which is why the source contrasts the Delaware LLC with the Cayman SPC, or segregated portfolio company. This is just a brilliant piece of legal engineering. An SPC is a single legal entity, but Cayman Islands statutory law allows that company to create distinct cells or portfolios within itself.
Okay, I want to understand the actual mechanics of that. How does an SPC legally segregate assets? I mean, if it's all one company, shouldn't the liabilities of one bad tokenized fund drag down the rest of them?
Under standard corporate law, yeah, absolutely. But Cayman SPC legislation specifically mandates the assets of Portfolio A are statutorily protected from the creditors of Portfolio B.
Wait, really?
Yeah. Let's say an SPC has one cell holding tokenized real estate and another cell holding high-risk tokenized crypto mining debt. If the mining debt defaults and the creditors come knocking, the Cayman courts will legally bar those creditors from attaching any claims to the real estate cell.
Oh, wow.
It allows an issuer to spin up dozens of different tokenized assets under one corporate umbrella without any cross-contamination.
Okay, so what does this all mean for the everyday investor? Because the source material actually uses this powerful analogy, it says choosing the wrong SPV is like building a skyscraper on sand.
I love that analogy because it's so true. The jurisdiction isn't just a tax play. It literally dictates the structural physics of the investment. It dictates investor rights, tax treatment, and redemption mechanics.
And the source mentions a few others too, right?
Yeah, it brings up Luxembourg RAFs, which are institutional-grade fund wrappers used a lot in Europe. And then trust structures, which are typically used for real estate and credit, and even specific loan participation vehicles for private credit tokenization.
So if you use a jurisdiction that doesn't legally recognize segregated portfolios and you try to run multiple tokenized assets through it, one default could trigger a cascade that just wipes out totally unrelated token holders.
Precisely. You could have the most elegant, heavily audited smart contract code ever written. But if the legal structure is domiciled in a jurisdiction with no established corporate case law, the stability of the entire product is just an illusion.
Okay, so let's say we've built an airtight vault. We have an independent Delaware LLC or a Cayman SPC. The assets are legally ring-fenced, the corporate governance is pristine. But a perfectly built vault in Delaware or the Cayman Islands is completely useless if the doors are left unlocked. We need guards. A legal structure needs a physical operator.
And this is the realm of the custodian. In traditional finance, a custodian's job is relatively straightforward. You know, they hold the stock certificates, the treasury bills, or the physical gold, and they just ensure those assets aren't stolen or lost. They are the trust layer.
Right, simple enough.
But what's fascinating here is the unique complexity that tokenization introduces to this role. Tokenization demands a dual-layer custody reality.
Dual-layer custody. So you're talking about safeguarding both the physical asset in the real world and the cryptographic keys on the blockchain.
Exactly. The custodian in a tokenized ecosystem has to bridge two entirely different paradigms of security. Institutions must safeguard both the physical real-world asset and the digital token. If the custodian fails at either layer, the entire token fails. Let's use an extreme example to see how this actually works.
Sure.
Imagine a tokenized vault of physical gold bars. The primary layer of custody is physical. The custodian has to operate a highly secure, audited warehouse with armed guards and biometric locks to ensure the gold physically remains there.
Right. But the secondary layer is the digital token representing that gold, which requires securing the private keys to the smart contract that mints and burns those tokens.
And this creates what we call the decoupling problem. What happens if the custodian's physical security fails? Say an employee at the warehouse manages to sneak a gold bar out. In the real world, the asset is gone.
Just stolen.
Right. But on the blockchain, the token representing that gold is still actively trading on a decentralized exchange. It becomes a ghost token. It represents an asset that no longer exists.
And conversely, what happens if the physical warehouse is perfectly secure, but the custodian's digital security is breached? Like a hacker steals the private keys and drains the tokens into an anonymous wallet.
In that scenario, the physical gold is sitting safely in a vault, but the legal chain of ownership represented by the tokens has been completely severed. The hacker now holds the cryptographic proof of ownership, even though they stole it.
That's terrifying.
It is. In either scenario, a failure at the physical layer or the digital layer, the tokenized product just collapses.
Which totally reframes how I look at the major players entering this space. For years, the prevailing narrative was that blockchain technology was going to bypass traditional banks entirely. But when you look at the sheer liability of dual-layer custody, it makes complete sense why massive legacy institutions, the global banks, the heavy-hitting trust companies, and regulated digital asset custodians are suddenly dominating this new market. They are becoming the essential guardians of the vault.
Exactly. They are the only entities with the balance sheets, the insurance policies, and the regulatory infrastructure to absorb that kind of complex liability. I mean, a tech startup might write better code, but they don't have $100 billion in insurance to cover a decoupled asset scenario.
No, definitely not.
The legacy custodians are stepping in because they can underwrite the trust required at both the physical and the cryptographic layers.
Here's where it gets really interesting, though. We have the legal vault, we have the dual-layer custodians guarding the assets and the keys. Now we have to figure out who sets the rules for who is actually allowed to walk through the front door and trade these shares. And the source material highlights a massive paradigm shift. A lot of people assume that putting a financial asset on a public blockchain means anyone can trade it freely. 2447 with zero oversight.
That is the assumption, yeah. But the reality for institutional assets is the exact opposite. Tokenization doesn't eliminate regulatory compliance. It automates it. It encodes it directly into the asset itself.
Programmable law. Instead of a compliance officer manually checking a PDF to see if an investor is legally allowed to buy a specific private credit token, the smart contract basically acts like an automated bouncer.
Yes. The term the source uses is programmable compliance, and the invisible architecture of it is incredibly powerful. In traditional finance, compliance checks like KYC and AML, so know your customer and anti-money laundering.
Right. Standard banking checks.
Exactly. Plus, investor accreditation, jurisdictional restrictions, transfer lockups, these are heavily manual processes. They happen at the broker level. If we connect this to the bigger picture of tokenization, those checks are moved from the broker down to the asset level. The smart contracts turn these rules into programmable compliance.
Okay, walk me through the actual mechanics of that. If I try to send a restricted tokenized asset from my wallet to your wallet, how does the smart contract physically know whether the trade is legally compliant?
So, the smart contract governing the token is programmed to interact with an on-chain identity registry or a compliance oracle. When you hit send in your wallet, the transaction doesn't immediately settle. First, the smart contract pings the registry and runs a series of conditional checks.
Like checking an ID at the door.
Exactly. It asks, does the receiving wallet address belong to an entity that has passed all required background checks? Is the receiver located in a jurisdiction where this asset is legally approved for sale? Is the asset currently subject to a mandatory legal lockup period?
So the smart contract is querying a whitelist in real time.
Yes. And if the receiving wallet address isn't on that verified whitelist, or if a lockup period is currently active, the smart contract's transfer function simply reverts. The transaction physically cannot execute on the blockchain.
Wow.
It doesn't matter how much gas fee you pay. The code denies the transfer based on the legal parameters encoded into it.
That's a fundamental shift in how markets operate. You're taking compliance from being a reactive post-trade audit process and turning it into a proactive, pre-trade physical law of the network. But what about when things go wrong with the asset itself? The source mentions that programmable law also applies to defaults.
Right, and this is where the integration of legal contracts and smart contracts gets highly sophisticated. Let's say the tokenized asset is a portfolio of corporate debt, and the underlying borrowers are required to make a yield payment into the SPV's bank account by the first of every month. The smart contract can actually be programmed to monitor an oracle connected to that specific bank account.
So if the first of the month passes and the oracle reports that this bank account hasn't received the cash,
the smart contract automatically triggers a default state. It might be programmed to instantly freeze all secondary trading of the token to prevent information asymmetry.
that makes sense.
It might automatically release a cryptographic escrow containing the legal documentation required for the SPV's independent directors to begin liquidating collateral. The code is literally executing the initial legal remedies that were drafted into the SPV's operating agreement.
Okay, so let's take a step back and look at the whole picture. We have all the pieces on the table now. The SPV holding the asset, the custodians managing the dual layer risk, and the smart contracts acting as an automated programmable compliance department. How do they interlock? And more importantly, how can you, the listener, actually use this information to protect yourself?
Well, you have to look at what the source calls the full stack. Tokenization is an interlocking chain of dependencies. You have the SPV holding the asset, the custodian safeguarding it, the token representing ownership, the compliance framework governing behavior, and smart contracts automating the enforcement. If any single layer in that stack fails, the entire product is compromised. Institutional-grade tokenization demands institutional-grade legal engineering.
Which leads perfectly to the due diligence framework. Based on the source material, I want to walk through this legal structure checklist so you know exactly what to look for when evaluating a token. First up, SPV jurisdiction. If you look at the prospectus and you can't clearly identify the jurisdiction of the SPV, or if it's domiciled in a region with absolutely no history of corporate case law, it's a massive red flag. You need to know if it's investor-friendly, regulated, and globally recognized.
Exactly. The second failure mode to detect is custodian quality. You need to verify that the custodian holding the real-world asset and the digital keys is entirely independent from the entity issuing the token. Are they licensed, insured, and independent?
Because if the issuer is custodying their own physical assets, there is zero objective friction preventing them from mismanaging or encumbering the underlying collateral. We've seen exactly how that plays out in the crypto space when custody and exchange operations are blurred under one roof.
Yeah, it rarely ends well.
The third thing to scrutinize on the checklist is the compliance framework. Are transfers securely controlled and transparent? If the token allows purely anonymous, permissionless transfers for an asset that clearly qualifies as a security, you aren't looking at a financial revolution. You're looking at an unregistered securities offering that is going to get nuked by regulators.
Absolutely. And the final, perhaps most critical item on the checklist is enforcement rights. You need to read the documentation to see exactly what the legal sequence of events is during a default. Who actually controls the collateral? Who has the authority to liquidate the underlying asset? How is the cash from that liquidation returned to token holders?
If the marketing material talks endlessly about the blockchain's transaction speed and the expected yield, but goes totally silent on liquidation mechanics, you should probably walk away. Because when the market crashes and the borrowers stop paying, the transaction speed of the blockchain doesn't matter at all. The only thing that matters is the legal enforceability of the SPV.
Law is the foundation of trust, and trust is the foundation of tokenization. Tokenization doesn't change that reality. It just requires a much more complex, integrated approach to building that foundation.
So we started this deep dive looking at the illusion of tokenization. The idea that it's all just sleek interfaces and frictionless code. But the reality revealed by this institutional playbook is far more profound. It takes an incredible amount of legal engineering, jurisdictional strategy, and dual-layer security just to make a digital transaction feel simple.
And as this market continues to mature, I really want to challenge the listener to think about their own portfolio. The source leaves us with an open challenge asking, which legal structure do you think will ultimately become the global standard for tokenized assets? Will the predictability of the Delaware LLC maintain its dominance, or will the segregated flexibility of the Cayman SPC win out?
Or perhaps a new, entirely bespoke jurisdictional framework will be designed specifically for on-chain assets. It's a space that is evolving in real time. And the institutions that ultimately dominate it won't just be the ones with the best developers. They'll be the ones with the most innovative legal teams.
This raises an important question, though, and it's a final provocative thought I want to leave you with. We talked about how smart contracts and legal agreements are becoming deeply intertwined, right?
Yeah.
But if a smart contract is now automating legal compliance, and the code is literally enforcing what happens during a default, what happens if there's a bug in the code?
What do you mean? Like a discrepancy between the code and the paperwork?
Exactly. In this new programmable economy, if a software glitch in the smart contract freezes your assets, but the legal operating agreement of the SPV says you have the explicit right to trade them, which law wins?
Oh, man.
Do you sue the lawyer who drafted the framework, or do you sue the software developer who wrote the smart contract? When the law breaks in this new system, who is actually liable for the bug?
That is a massive legal gray area. If the code is law, but the law is also law, we're going to see some fascinating and probably incredibly expensive court battles trying to untangle that. The invisible legal engine room is only going to get more complicated from here. Keep that in mind the next time you see a tokenized asset promising a frictionless future. Thanks for joining us on this deep dive.
1, 2, 3, 4.
Yeah.